When does the trial process begin after an arrest? In recent news, many people are asking an important question. When does the trial process actually begin after an arrest? With the legal landscape constantly evolving, understanding this process is essential. Just yesterday, several high-profile cases highlighted the timeline from arrest to trial, making it a hot topic for many viewers. If you or someone you know is facing legal challenges, you will want to know what to expect. The trial process in criminal defense starts after a series of initial steps following an arrest. First, after an arrest, the individual is booked into the local jail or police station. This booking involves taking fingerprints, photographs, and recording personal information. Soon after, the person is brought before a judge for an initial appearance. During this appearance, the judge informs the individual of the charges against them and advises them of their rights. Next comes the arraignment. This is where formal charges are read to the defendant. At this stage, the defendant must enter a plea. The options include guilty, not guilty, or no contest. This plea is a significant moment in the process. In some jurisdictions, a preliminary hearing may follow. This hearing helps determine if there is enough evidence to proceed to trial. Not every case requires this step, and it varies by location. Before the trial, the defense attorney may file pre-trial motions. These motions can challenge the validity of the arrest or suppress evidence that may not be admissible. Finally, we reach the trial itself. This is where the prosecution presents its case against the defendant. The defense has the opportunity to challenge the evidence and present its own case. Depending on the jurisdiction and the nature of the charges, the trial can be by jury or by a judge alone. If the defendant is found guilty, a sentencing hearing will be held. During this hearing, the appropriate punishment is determined. This can involve a pre-sentence report and arguments from both sides regarding the severity of the sentence. For minors, the process is slightly different. If a minor is arrested, the case is typically referred to juvenile probation for an initial review. Depending on the circumstances, the case might be resolved through a diversion program, or it may proceed to a juvenile court hearing. Understanding when the trial process begins after an arrest is vital for anyone involved in the legal system. Keeping track of these steps can help individuals navigate their cases more effectively.